Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and the 18th of May 2023 be now read a second time. I have the privilege, Mr. President, today to pilot the bill brought from the House of Representatives. The bill is short and comprises 5 clauses to achieve 3 principal objectives. 1, the extension until the 18th of May 2023 of the terms of office of councillors and aldermen whose terms expired on the 2nd of December 2023. 2, to provide for elections within 3 months of the 18th of May 2023. 3, to validate the functions and actions of those councillors and aldermen between the period 2nd December 2022 and the 18th of May 2023. Mr. President, 2 significant circumstances have promoted the need for this bill and deserve appropriate reflection. The first is the mandate of this government to empower the people of Trinidad and Tobago to improve their lives within their communities. The second concerns an important part of the history of this country and the considerations which have informed the passage of local government legislation and which serve to lend clarity to the approach which we take today. As to the first, the mandate of this government, Mr. President, is to empower the people of Trinidad and Tobago. The Honourable Prime Minister has placed on record already of this Parliament the amendments introduced in 2020 by this government to bring about comprehensive reform of the Municipal Corporations Act 2020. That record exists in the Prime Minister's statement delivered in the House on the 24th of May 2023. Without repetition, it suffices for me to say that as part of my pilot today, I entirely adopt that statement of the Honourable Prime Minister as informing our considerations today for the passage of this bill into law. This brings me, Mr. President, to the second point of importance, the clarity and simplicity of this bill against the historical evolution of our local government legislation. That clarity promotes the passage of this bill today by a simple majority, so that the people's business may proceed, respecting the government's adherence, always, to democratic principles, consistency in governance, and respect for due process and the rule of law. Mr. President, local government in Trinidad and Tobago started in Trinidad in 1927, when Trinidad was divided into 8 counties by the Division of Trinidad Act. County councils were established in 1945, with further legislative enactments in 1967 by Act No. 22 of 1967. In the consultations informing our constitutional ethos and development after independence, the topic of local government was addressed by national stakeholders before the 1974 Wooden Commission, as citizens contributed to the drafting of the 1976 Republican Constitution of Trinidad and Tobago. In 1990, Mr. President, the Municipal Corporations Act was brought into force. Throughout, the law governing local government has remained under development, driven in particular by this government. As we know, further amendments of a novel nature were introduced by the 2022 Act, the Miscellaneous Provisions Local Government Reform Act No. 11 of 2022. Mr. President, here we are today, therefore, with the benefit of the most recent judicial interpretation of the Municipal Corporations Act as amended, pronounced by the Judicial Committee of the Privy Council on the 18th of May 2023 in the Maharaj case. The Privy Council accepted the Court of Appeal of Trinidad and Tobago's record of the historical evolution of this legislation up to the proclamation of Section 11.4 and 12.5 of the Municipal Corporation Act. The Judicial Committee has held that the extension of the term of office of incumbent councillors and aldermen by 1 year constituted no violation of the Constitution of Trinidad and Tobago, but that, B, that extension by amendment could not be interpreted as applying to the incumbent councillors and aldermen whose terms expired on the 2nd of December 2022. Assembled as we are here today, Mr. President, our task today is simple. We accept the ruling of the Privy Council. Every statement by and on behalf of the government since that judgment has been unequivocal and clear, because this is a democratic government which respects due process and the rule of law. Mischief makers, Mr. President, would seek to suggest otherwise, but I am confident that the discerning, intelligent population of this republic will not allow misrepresentations to cloud the clarity of the government's intention. We accept that today we must provide with the clarity that this bill provides for the period that has run its course since December 22nd to the 18th of May 2023, the date of the decision of the Privy Council. Mr. President, permit me briefly to address a concern which has been put on the record of this House by the Honourable Senator, Honourable Dr. Varma Diyal Singh, who appears from recent contributions in this very Senate on the 23rd of May to be troubled by the majority of the Privy Council ruling as it did. He appears from his remarks to be troubled by the fact that he considered that this Honourable Senate somehow participated in taking away the rights of persons to vote. Mr. President, I ask your leave to reassure the Honourable Senator and this House that there exists no reason for his concerns. This Senate can stand proud and hold its head high for that which it did in passing the 2020 Act into law and the subsequent proclamation which brought sections 11.4 and 12.5 into force in November 2022. I give this assurance, Mr. President, to the Honourable Senator and to this House for the following reasons. One, the clarity of that which was effected by the Senate has the support of 6 judges of our higher judiciary of the 9 who pronounced on this matter. And this is not sophistry, Mr. President. Those 6 of the 9 judges accepted the wisdom and clarity of that which was approved by this august House. And the difference which held sway was really only, as far as the majority was concerned, limited to a question of statutory interpretation of words used in the bill at the time. 2, nothing passed by this Senate has violated the Constitution of Trinidad and Tobago, and nothing passed by this Senate has taken away the constitutional right to vote of the citizens of this country. All 5 judges of the Privy Council were unanimous on this, as were the 3 judges of the Court of Appeal. The very history of Trinidad and Tobago, to which I have earlier referred above, carefully reviewed by our Court of Appeal from paragraphs 46 through 69 of its decision dated 10th February 2023, for those who wish to take the time to read that illuminating judgment, affirmed in significant measure by the Privy Council, is an aid, an interpretative aid, in construing the passage of legislation which is accepted by the very Privy Council in one of the cases relied on by the Court of Appeal when it adjudicated on the Act at the time. I refer, Mr. President, to the case of the Commissioner of Prisons and CPASAD from this very country, reported at 2021 UKPC 13, cited by the Court of Appeal in the Mirage case, and the advice of Sir Bernard McCloskey in these terms, quote, "The board considers that the court engaged in the interpretation exercise must be alert to the historical context of the constitutional instrument in question. It is trite to add that the constitutional provision under scrutiny must be construed by reference to the whole of the instrument in which it is contained. Accordingly, Mr. President, 3, in its judgment in this local government case, the Privy Council was informed by the historical review of local government in Trinidad and Tobago, so carefully reviewed by our Court of Appeal, and was able for that reason to reject unequivocally the main constitutional plank which had been argued by the applicant, Mr. Maraj, in the case before the High Court and the Court of Appeal in these terms. And I quote from paragraph 20 of the Privy Council majority judgment, quote, "On any footing, the absence of any detailed provisions concerning local government elections leads to the inevitable conclusion that a change in the length of the terms of office of incumbent councillors and aldermen cannot amount to a contravention of the Constitution. The term for which representatives have been elected is important, but an increase by 1 year in the term of incumbent councillors and aldermen does not of itself breach any provision of the Constitution." Close quotation marks. Mr. President, let me be clear, as I have been since I have spoken to and about this judgment of the Privy Council. This government accepts the interpretation ruling of the majority of the Privy Council, which ruled that the amendments effected by sections 11.4 and 12.5 of the 2020 Act do not apply to the incumbent councillors and aldermen. It is why we are here today, to pass this bill into law, to, among other things, provide for an election to take place within 3 months of the 18th of May, 2023. I emphasize what I have said above, Mr. President, by way of comfort and reassurance to the Honourable Senator Dr. Diyal Singh. Indeed, Mr. President, it is instructive that the minority in the Privy Council and the majority in the Maharaj case disagreed with the majority on this point of interpretation at paragraph 59, subparagraphs 1 and 2 in these terms. And I quote from that minority judgment. "The plain language of section 11.4 of the MCA, read on its own and in its context, as part of section 11, uses councillors as including incumbent. Both its language and its functional purpose apply to incumbents for whom election is a past event. If councillors were to mean only those to be elected at the next election, there would be no statutory provision in the Act at all specifying the term of office of incumbent councillors. That is a strange vacuum which construction should, if possible, avoid." Close quotation marks. Permit me further, Mr. President, in speaking to the decision of the Privy Council, which has us here today, to refer to an authoritative column written by the nationally respected Dr. Terence Farrell and published on Sunday, the 21st of May, 2023 in the Sunday Express. And I read from parts of that Sunday column in order to give the reassurance for the last time to the Honourable Senator Dr. Varma Diyal Singh that there has been no violation of the Constitution by this Senate. Because I would not wish the listening public to think that it's only this gentleman at the podium at the moment who holds the view which I now read. And if you will permit me, in the first column of 6, I quote, "It is certainly true that the majority rules in the appellate court decisions. However, dissenting judgments have in many instances proved to have been correct. Lord Atkin's dissent in Liversidge is famous. Sat Sharma's dissenting judgment in Sinanan on whether a person accused of murder could access bail proved to be correct. Lord Bingham, perhaps the finest English jurist of his time, and 3 other judges dissented in Matthew, which sadly was unanimously reaffirmed by the Judicial Committee of the Privy Council in Chandler. Lord Bingham has also dissented in Surat. Dissenting judgments, says Dr. Terence Farrell, are often quite valuable, if nothing else, and I commend this to the Senator Dr. Varma Diyal Singh, a dissenting judgment suggests that the matter is complex and not susceptible of easy resolution." Mr. Farrell, Dr. Farrell continues, with your leave, Mr. President. "In a detailed and powerful dissent, Lord Briggs and Lord Kitchen, examining the history of the Municipal Corporations Act, argued that it was obvious that sections 11 and 12 applied to incumbents. In fact, they point out that the majority's interpretation leads to absurdity. And in the last column of Dr. Farrell's opinion, this is what he says. The dissenting opinion of Lord Briggs and Kitchen in support of an excellent Court of Appeal judgment by Justice of Appeal Prakash Musai and agreed with by Justices of Appeal Abood and Lucky, effectively laid to rest the constitutional challenge, and they perceived no lack of clarity in sections 11 and 12. In my respectful view, Dr. Farrell concludes, in this case, the minority were right and the majority got it wrong. While there are perhaps serious political implications, the majority judgment, which drew out both the President and Deputy President of the United Kingdom Supreme Court, has added nothing to our jurisprudence. If I may continue, Mr. President, I emphasize the above by way of comfort and reassurance to the troubled Senator Dr. Diyal Singh. Mr. President, the compelling reality for purposes of this bill and until this judgment was delivered on the 18th of May, 2023, is that the corporations continued to function lawfully, consistent with the provisions of the Municipal Corporations Act, Chapter 2504, and supported until then by the unanimous decision of the Court of Appeal of Trinidad and Tobago. This reality is put beyond doubt in the applicability, if it were needed, of the de facto officer doctrine, which is summarized in the authoritative text, Wade and Forsyth, Administrative Law, 9th edition, 2004, from pages 285 to 286, if I may quote, Mr. President, with your leave. The acts of an officer or judge may be held to be valid in law even though his own appointment is invalid and in truth he has no legal power at all. The logic of annulling all his acts has to yield to the desirability of upholding them, where he has acted in the office under a general supposition of his competence so to do. Unquote. The incumbents in this particular case, the aldermen and councillors, continued in office initially on the basis of the view held by the government that the proclaimed amendments applied to them as incumbents, thereby extending their terms of office from 3 to 4 years. This was plainly not an unreasonable view, Mr. President, held in good faith, and particularly since this was also the view of an unanimous Court of Appeal. More directly, the incumbents acted in their offices after the 10th of February, 2023, the date of the Court of Appeal decision, pursuant to that decision, which held on that date that the 4-year term applied to them. It is plain, therefore, that the incumbents acted under the general supposition that they were competent so to act, and the logic of annulling all of their acts has to yield to the desirability of upholding them. It follows then, Mr. President, that despite the 18th of May decision of the Judicial Committee, the actions of the incumbents should be considered legitimate in the eyes of the law. The incumbents continued to perform their functions, and the state duly paid their salaries in exchange for their services. In addition, the wider public received the benefit of those services. Indeed, there is a case to be made that the government need do nothing to alleviate the uncertainty created by the decision of the Privy Council that the term of office of the incumbents expired in December 2022. Mr. President, this is a responsible government. There is a good case, therefore, to be made for legislatively validating their acts. The public interest advantage of doing so is that it removes uncertainty. Any uncertainty which has been created with regard to whether the public may rely on their acts and decisions, and avoids any continuing uncertainty and indeed any potential for mischievous, opportunistic maneuvers. I turn now, Mr. President, to the clauses of the bill. Clause 1, the short title. This act may be cited as the Municipal Corporations Extension of Terms of Office and Validation Act 2023. That speaks for itself. Clause 2, interpretation. In this act, Mr. President, as amended in the House on Monday the 29th, on an amendment which I moved, Clause 2 reads, councillors and aldermen mean the persons who served in the corporate office of the council during the period December 2nd, 2019 to May 18th, 2023. The rationale for that clause is that it is intended that this act to apply to all councillors and aldermen who served in that period, 2019 to May 18th, 2023. Clause 3. The extension of term of office of councillors. It reads, the terms of office of the councillors and aldermen which expired on 2nd December 2022 are hereby extended until the 18th of May 2023. The rationale. We have already acknowledged, Mr. President, the applicability of the de facto officer doctrine based on public policy, so that this provision is indeed in obedience to the further public interest principle being introduced, as Latin scholars would say, ex abundante cautela. The advantage of doing so is that it removes any uncertainty which has been created with regard to whether the public may rely on their acts and decisions, and avoids the possibility of further litigation. Councillors and aldermen are required to represent effectively the interests of the electoral district, municipality for which they are elected, and deal with constituents' inquiries and representations. Councillors work continuously, diligently, and tirelessly to improve the lives of all persons in their communities within the remit of local government. These local government responsibilities include, among others, public health, municipal police, spatial planning and building inspectorate, disaster management, repairs and maintenance to government schools and specified public buildings, cemeteries and crematoria. Clause 4. An election referred to in Section 11.1 of the Municipal Corporations Act for the year 2023 shall be held within 3 months of the 18th of May 2023. The rationale for that, Mr. President, the incontrovertible reality is that the proclamation issued on the 2nd of November, which brought a small number of the provisions of the 2022 Act into force with effect from the 8th of November 2022, substituted 4 years for 3 years as the periods of office of councillors and aldermen. During the currency of the challenges brought in the High Court and the Court of Appeal, the law remained in force. The government, led by the Right Honourable Dr. Keith Rowley, Prime Minister of Trinidad and Tobago, fully endorses that local government elections must now be held so as to ensure the continuity of the life of local government corporations for all persons throughout the country. This clause provides for the period being within 3 months of the 18th of May 2023, and that the writs of election shall be issued in due course by the Elections and Boundaries Commission. This ensures that each member of the public can exercise his or her right in accordance with the Municipal Corporations Act and related legislation to participate in the local government election. Clause 5. And this brings me, Mr. President, to alert this Honourable Senate that I will be moving an amendment at the appropriate time. Clause 5 reads, where the councillors and aldermen under Section 3 exercise the functions of councillors and aldermen between the 2nd of December 2022 and 18th of May 2023, and thereafter exercise the functions of councillors and aldermen up until the commencement of this Act, the exercise of those functions and all acts or things done pursuant thereto shall be deemed to have been as valid and effectual as if the Municipal Corporations Act expressly empowered them to exercise those functions. I should say from the outset, Mr. President, by way of explaining, which I will do in more full detail, the amendment which I shall move is that I have reflected since Monday on contributions which have been made to Clause 5, and I have benefited from a very illuminating conversation which I've had with Independent Senator Dr. Paul Richards, which I acknowledge publicly. The rationale, Mr. President, of Clause 5 will be, in due course, to validate the functions and all acts or things done by councillors and aldermen for the period between the 2nd of May 2022 to the 18th of May 2023. The hard work, diligence, and daily achievements, progression of projects vis-à-vis the use of plant, machinery, and equipment by the councillors and aldermen in these two limited periods are recognized and do not go unnoticed by this government and are to be validated by this bill once it becomes law. In the period between the 18th of May 2022 to the date of the election, when that election is called within the prescribed period, the mayors remain in office, and that speaks to the continuity that is provided for by Section 15 of the Municipal Corporations Act. Local government bodies have several responsibilities which are well known. They are set out. I need only mention a few of them: construction and maintenance of local roads and bridges, construction and maintenance of minor drains and minor water courses, local health, general sanitation and rodent control, garbage collection and disposal, development and maintenance of recreation grounds, parks and public spaces.
AG, Attorney General, I think a senator would like to give way. Senators, just a reminder, you can raise in your seat and ask the speaker if they would give way.
I beg your pardon. Apologies to the senator. Yes, Senator, I give way.
Senator, thank you, Attorney General. Just to confirm for the record, so the amendment that you have moved in relation to Clause 5 is deletion of the words "and thereafter."
Yes, the amendment which I will be moving is, when you look at Clause 5, the words to be deleted will be "and thereafter exercised the functions of councillors and aldermen up until the commencement of this Act."
Thank you.
That will be the amendment which I will propose. Thank you. So just to conclude, as I was about to, and I'm grateful to Senator Vera for that clarification. In conclusion, Mr. President, this bill underscores the government's vision for an effective local government system to facilitate the transformation and modernization of local communities to which this government has been committed. Indeed, the policy on local government reform in the Cabinet-approved 2016 policy document states, and I quote with your leave, "Local government is the democratic representative of communities. It is closer to the people than central government and can be dubbed the voice of communities. The People's National Movement will ensure that with the devolution from the Ministry of Local Government, the municipal corporations report directly to the Ministry of Finance, particularly on fiscal matters, and are adequately equipped and resourced to provide quality service to their communities and may improve the quality of life for all citizens." Mr. President, thank you for this opportunity to provide clarity and explanation as to the purpose and remit of the 5 clauses within this short bill, which has significant impact as part of the package of the government's legislative amendments encompassing local government reform. I beg to move.
Honourable Senators, just before I put the question, just a reminder that during the course of the debate, if you do have amendments, to please circulate them prior to committee stage through the clerks of the House. Honourable Senators, I shall now propose a question for debate. The question is that a bill entitled "An Act to Extend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and the 18th of May 2023 be now read a second time." Senator Mark.
Thank you, Mr. President. Mr. President, I rise at this time to address a very dangerous piece